Hello, my name is Susan Graham, and I'm a certified elder law attorney. This is the Beyond Retirement Learning Series, and today we're going to discuss what do you do when a spouse dies. Now, I know your goal is to get information, and my goal is to provide you with that information and also to motivate you to move forward to establish and accomplish your own estate planning goals. So let's get started. I'm going to talk to you about two stories. One of a family who had no plan in place and another one who actually had a plan. So the family that had no plan in place, what happened is one of the spouses died. And when that individual died, what does the survivor do? Well, first of all, who you notify? The people you notify if that spouse died at home and there was no medical person in attendance, then it's necessary to contact the coroner, the county coroner, and then they'll deal with that. And then, of course, you need to deal with how to handle the body and what to do with the last remains. Is that person going to be cremated or buried, and all those details. So who do you notify? Really, the only person is the coroner if someone died at home, or if it's someone has medical attendance, then it actually needs to be the hospital or the doctor or the hospice people will take care of that. The next step is who's going to be in charge of handling the finances of the deceased person. Now, granted, it's the spouse, and the surviving spouse may have full access to the monies, but there are certain bills that need to be paid. Certainly the last funeral bills, the last medical bills, and other associated regular expenses. In addition, if the person, the spouse who died, was on Medicaid, receiving benefits from the state and federal program that helps pay for long-term care, and then it's necessary to notify the Idaho Department of Health and Welfare to let them know, because they have a right to file a claim against the estate of the decedent. Now, when there's a surviving spouse, they can't really do anything to assert that claim, but once you're both gone, once the surviving spouse as well as the first spouse to die who was on Medicaid, once they're both gone, then the state of Idaho is entitled to be reimbursed for what they paid on behalf of the Medicaid recipient. It then comes down to, how does the surviving spouse get control of those assets? How do they remove the deceased spouse names from those assets? And where are the monies supposed to go? Well, if you have no plan in place, then there's going to be the deceased spouse name on a variety of things. Certainly the car title is often in the name of both spouses. But that's normally not a problem, because either spouse can sign to transfer that car title or to get a lien on that car. And now the house, if they own real property, they own a home or they have a condo or they have a cabin, that house normally has both names on the title. And maybe the surviving spouse doesn't want to do anything about it, and that's fine. But if that spouse ever wants to sell that property or use it as security to get a loan, then they're going to have to go and probate the estate of the first spouse to die. Probate means you have to go to court and say, hey, judge, my spouse died. I want to be in charge, and I want the power to be able to sign on behalf of my dead spouse. That's what it all comes down to. Who's got the power to sign to grab these titled assets and do what needs to be done with them? And if there are things that have beneficiary designations, like retirement accounts or life insurance, all you do is submit a claim to the company, and they'll ask for certain paperwork. Usually they ask for a certified copy of the death certificate, and you file all that paperwork, and whoever is named as the beneficiary or the recipient on a paid on death account, like at a bank account, that's the person who's going to get the money. But there are other things that may not have beneficiary designations, such as mutual funds, brokerage accounts, stocks, bonds, other things like that. And then how do you get those? Again, the law says in Idaho, if the decedent, the dead spouse, had more than $100,000 of assets, titled assets in the decedent's name only, then it's necessary to probate that estate. Again, the healthy spouse, the surviving spouse, would file a petition with the court and say, hey, judge, my spouse is dead. Please let me handle things, and be appointed as the individual who can do that, who can sign on behalf of the dead person. We call that person the personal representative in the state of Idaho. Other places they're called executor. It doesn't matter. It's just the name that's attached to who's got the power to sign on behalf of the dead person. And then the untitled assets, what I call the stuff. That's the tools, the guns, the painting, the china, the ring, those kinds of things, tractors even, they don't have a title. Again, you don't have to worry about getting the power to be able to transfer those assets, but who's entitled to them? So the next problem is, who gets all this? Who gets the property that belongs to the first spouse to die if there's no estate plan in place? Well, Idaho has a default provision. And what the Idaho law says is, if you're married, the presumption is all of the property is community property. Idaho is a community property state, and there's two kinds of property that people can own when they're married. One is community property. That presumes that everything belongs to the two of you, no matter how it's titled, belongs to the dead spouse and the community spouse. And the law says that it all goes to the community spouse. Now, there's another kind of property that can be owned by a spouse, and that's called separate property. Separate property is something you owned before the marriage, or you received as a gift or an inheritance during the marriage. So a gift or an inheritance went to just one spouse. And Idaho law says if there's children of the deceased spouse, the first one to die, then the children get a portion of that money, and the surviving spouse gets a portion of that money. Now, to make things even a little more confusing, is Idaho law says income generated by separate property. So you have a house that the first spouse to die owned before the marriage, and that house became a rental, but it had a mortgage on it. So what the law says is income from separate property, rental income, or dividend income for stock that was owned just in the name of the first spouse to die, because that was something that spouse owned before the death and before the marriage, or improvements to the separate property. So the rental was painted, and it cost some money to paint it, but that painting was during the term of the marriage, and that painting increased the value of the home. What Idaho law says, the income from separate property is community property. That's dividend, rental, interest income. Or because the increase in the value of the separate property was because of a community property contribution, meaning that you spent marriage money to pay for the painting, that's community property. So now the separate property, which is like a fishbowl, okay? Think of a fishbowl with lots of white marbles. And then during the term of the marriage, that's the white marbles, a separate property. But during the term of the marriage, black marbles are dropped into that. The black marbles would be going over and scraping the paint and using marriage money to paint the house. That's a community property contribution to a separate property asset. There are also black marbles that go in there every time there's a rental payment, the net rental payment. Or you use community property funds to pay the mortgage on the rental. And, that could be, granted there's the interest, which poof goes away, but there's a payment down on the principal. This gets to be kind of confusing about how much is separate and how much is community property in this fishbowl that started out white marbles and now has a lot of black marbles. So if, when the first spouse to die has separate property and children from a prior marriage, then often there's a dispute about how much of that separate property is separate property and how much of that is community property. That gets to be kind of a mess, certainly for the surviving spouse. So that's what happens when there's no plan in place. When a spouse dies, there are a series of steps, and usually it's the surviving spouse who takes those steps, but they want to be certain that they get the power to be able to sign on behalf of the deceased spouse to be able to handle those affairs and pay those debts and ultimately distribute the property out where it needs to go. So how about a better plan? There's always a default plan for the state of Idaho, but if you want to have control over your assets and what happens to your family and protect your family, then planning is really useful. So let's talk about some planning techniques. One of the things you can do as a married couple is you can sign a contract that says you don't care who dies first, the other one gets all the property if that's what you want. And you put in that contract the legal description of the home you have. So Lot 2, Block 10 of the Franklin subdivision in Ada County. And you record that agreement in the county where that land is located. And if you also own property up in Latah County, you would do the same thing. You would record that agreement in Latah County with the legal description of the property that's in Latah County. Then when one of the spouses die, all the surviving spouse has to do is get a certified copy of the death certificate of the first spouse to die, and also sign a little affidavit that says my spouse is dead. Put this real property that's described in that contract into my name, the survivor's name. So that's a pretty easy way to avoid having to go to a death probate for real property. Because even if the real property is all community property and it's got both names on it, then you have to probate the estate. So if you do this agreement and record it in the counties where the real property is located when the first spouse die, that's an easy way to transfer the real property to the surviving spouse. Another thing you can do is you can make beneficiary designations on life insurance, annuities, those kinds of agreements, retirement accounts that say when I die, then my property goes to my spouse, and my spouse fails to survive, may go someplace else. That also makes it very plain. That's an independent contract and it's an enforceable contract. So that's great. That's another way to handle it. And then again, you can make bank accounts and some other accounts, paid on death accounts or transfer on death accounts. They're called POD or TOD accounts. So that's another way to make it easy. Again, when the spouse dies, the surviving spouse just takes a certified copy of the death certificate or provides it to those different companies, and they will transfer that account into just the surviving spouse's name. You can also hold some accounts, some brokerage accounts or some investments as community property with rights of survivorship. Again, that's a form you fill out prior to the death of either spouse. And then when one of you dies, again, you just provide a death certificate and show that to the company, and they have some other forms to fill out, and all the property in that account will be transferred to the survivor's name. So that's easy as well. Now, as to the stuff, that's untitled assets. Again, the tools, the ring, the painting, the china, the tractor. And it would be helpful for both spouses to sign a list as to who gets those items, but basically that's going to end up in the surviving spouse control. You can certainly sign a last will and testament that says, when I die, I want everything to go to my spouse. That's very helpful. At least that eliminates some of the difficulty with the children or children of a prior marriage. Again, there's an issue if there's separate property that was owned by the first spouse to die. Remember, I told you about that fishbowl with the white marbles and the black marbles. How much of that's community property, how much of that is separate property. If you say it all goes to my surviving spouse, then that's controlling. That overrides the law. That's a default law if there's no plan in place. But when you have, again, a will, it's necessary to go to court and say, hey, judge, I'm in charge, because you're nominated, the surviving spouse is nominated as the personal representative, and it also says where the property is going to go. Okay, there's one other thing you can do, and you can do a revocable trust. And it doesn't work for everybody, but some people like to use that technique. What that means is that both spouses during their lifetime set up a revocable trust. It's like they're setting up a little business, and they're both totally in charge. all of this, remember I said earlier, comes down to titled assets. Who has the power to grab a titled asset when somebody's not able to do that because of death? We talked about incompetence in earlier programs. We're talking death here. So oftentimes married couples sign a contract, a revocable trust that says we're going to be in charge of our affairs as long as we want. And any separate property is not going to have black marbles still built up in it. It's all going to stay white marbles. And then it says if they both manage it, if one of them becomes incompetent, who's going to handle it? Usually it's a surviving spouse or a healthy spouse. When one dies, the one who handles it, called a trustee, is usually the surviving spouse. There are certainly lots of variations to that. And it says in that contract, that trust, when one of us dies, what happens to the property? So if the first spouse to die wants their rental, their separate property rental to go to their kids, that's what it's going to say. But otherwise, most people say it all goes to my surviving spouse. And then, of course, when the second death occurs, it says where the money's going to go. Now, to make that work, to make it easy on the death of the first spouse, what you do is you just transfer all your titled assets into that trust. So now the rental will be the name of Frank and Betty, trustees of the Frank and Betty Trust. Frank and Betty Trust owns that rental. Same thing for their house. Same thing for their brokerage account. And the beneficiary designation on the retirement accounts, the life insurance, and the bank accounts is going to be the surviving spouse. And then when they're both going to go someplace else. So the advantage of that is you avoid the need of going to court. And you also coordinate your assets so that they match the distribution that both spouses want on the death of the first spouse and certainly on the death of the second spouse. When you have a plan in place, we still have the same people that notify when someone dies. You know, we're talking about you need to call a coroner or the healthcare people, and you need to deal with the mortuary to deal how we handle the last remains of the first spouse to die. But that's pretty much it. You know, it'd be nice, it would be appropriate to contact the children and other good family friends, but those are certainly not legal requirements. And you still have to pay the debts, no matter which version you do, whether you have no plan in place or you actually have a plan in place. I mean, those debts need to be paid that are the obligation of the deceased spouse. So let me talk about how do you set up these plans. You know, it's a tragedy. It's a heartache. Even if the spouse who died first has been ill for a long time, it's still a great loss. And it's just dreadful to have to deal with all these things. So the advantage of setting up a plan in place is that it makes it as easy as possible as you can for the surviving spouse. And if you've been married even a month or you've been married 50 years, you like your spouse. Pretty much everybody likes their spouse. Otherwise, why would you bother with it? So what I'm talking about, the value of planning ahead, is it gives you the peace of mind that the plan you set up is the one you want for how to handle things and protect your assets and your families when you die. So let's talk about what does it really cost? Because, you know, the elephant in the room is people say, oh my God, attorneys are expensive. And maybe it's too expensive for me to set up a plan. Well, let's talk about what you spend for other things. I mean, the first car I bought was like $2,500. You can tell, you know, I've been around a long time if that's what I paid for a car. But new cars these days are around $47,000. That's the average cost for a new car, which is quite breathtaking. That's more than my first house cost. And if you have a wedding, the average cost of a wedding these days is $28,000. And if you want to throw in a ring, it's $34,000. Now, who in their right mind gets married without a ring? That's just craziness. So, of course, you're going to have the wedding with the ring. What does it cost to do an estate plan? You can do it on your own. You know, you can go to LegalZoom and maybe pay them $500 and you get a series of documents. And you get to fill them out. Now, how do you know you filled them out right? And how do you know that you have the proper documents? nobody's ever going to know until you're dead, and that's a little late. It's too late to fix anything. When you come to our office, if you choose to work with me and we find we're a good fit and we can go forward to help you accomplish your planning goals, we come up with a plan. We talk about how do you want to handle things now while you're alive and doing great? Who do you want to rely on when you can't do things for yourself? We're all independent. We all want to do it ourselves, but you look around and it happens. People become unable to handle their daily business, in terms of physical care as well as financial care. And then, of course, the guarantee for each of us, you're going to die. Me too. So what happens in those times? So that's the purpose of the plan, to deal with the good days, if heaven forbid you become incompetent, and then the day you're gone. And those plans can cost quite a bit of money, but it's not just documents you end up with. You end up with a plan that actually accomplishes the goals you want. And our fees range from usually a low around $3,000 to maybe $10,000, depends on what version of your estate plan we're actually going to accomplish for you. We're going to help you accomplish for yourself. So if you want to partner with us to create an estate plan for you and your family, there is a way we can do that. There's an evaluation form at the bottom of your screen. If you fill out that evaluation form, someone from my office will contact you and ask a series of questions to see if we have the potential to be a good fit. And if so, then they'll set up an appointment for us to visit. There's no charge for that first 30 minutes, but during that time, we'll be able to figure out if it's worthwhile for you to go forward, to have us work together and partner together to help you accomplish your estate planning goals. In addition, when you fill out that form, we have some legal forms that are available at no charge on our website, so you could download those and fill those out if you want. That's the basics of estate planning, which would be a financial power of attorney, as well as a health power of attorney and a living will, which is a document that says, gee, if the day comes that you really are knocking at heaven's gate and you're terminally ill and they can't fix it and you're incompetent, you cannot communicate, then what do you want? How do you want to be treated toward the end of your life? So sign up for that and turn in that evaluation form. It would be my pleasure to be able to visit with you. And thank you so much for taking the time to listen to this program.